So good afternoon and welcome to our January Lunch and Learn program titled United States and Wisconsin Constitutions Under Fire. My name is Jane Powell and I serve as president of the local League of Women Voters of the La Crosse area. And on behalf of the board of directors, we thank you all for being here today. The League of Women Voters is a nonpartisan, nonprofit organization that has been dedicated to empowering voters and defending democracy right here in La Crosse for 100 years. Chokes me up when I say it. This program is being broadcast and recorded for later viewing on our website. We will have a question and answer time after the presentation, and our home viewers can type in questions that could be included at that time. So now, without further ado, I'm going to introduce Barbara Soderin from our program committee, and she will introduce our speaker today.
Thank you, Jane. And good afternoon. I had to think about that. Oh, okay, closer. Okay, Emily Lau is a staff attorney with the State Democracy Research Initiative, a nonprofit, nonpartisan organization at the University of Wisconsin in Madison. She joined the initiative after earning her law degree from Yale Law School. And while in law school, Emily was an intern at the San Francisco City Attorney's Office in the complex and affirmative litigation team, and a student in the San Francisco Affirmative Litigation Project Clinic, helping the San Francisco City Attorney's Office litigate cases under the California Unfair Competition Law. She was also an editor on the Yale Journal of Law and Feminism, and a member of the First Generation Professionals Board. Before law school, Emily worked in the California Governor's Office in the Brown and Newsom administrations. Now, this is Emily's first visit to our beautiful city of La Crosse, so let's ignore the temperatures outside and give her a very warm welcome.
Thank you so much for coming out here today on this somewhat chilly day to learn about the Wisconsin Constitution and the United States Constitution and the opportunities and challenges presented by amending these constitutions. So it's just a brief overview of the topics that we'll be discussing today. So I'll start out with a brief introduction of the two constitutions we'll be talking about, then we'll be discussing Wisconsin constitutional amendments, and then looking at the national context of state constitutional amendments generally, and then thinking about amending the US Constitution, and then the challenges and opportunities presented by these various efforts to amend both state and the federal Constitution. So to start out with, I think most people are generally familiar with the US Constitution. And I'm sure the folks in this room and watching online are also aware that we have a state constitution. Every state in the nation has a state constitution. And one of the notable things about state constitutions is that they are generally significantly more easy to amend than the US Constitution. And so the US Constitution has only been amended 27 times and only 17 times since 1791. But the nation's states' constitutions have been amended at least 7,000 times in total, and many states are on their second or third or fourth, or in some case 11th constitution. And so it's quite unusual for state constitutions to go without amendments for a significant period of time. So just a little bit of background about the US Constitution. The US Constitution has 4,400 words and is the oldest and shortest written constitution of any major government in the world. And one of the interesting things about the US Constitution is that it does not set forth requirements for the right to vote, nor does it guarantee the right to vote, even though SCOTUS has since read the right to vote into the Constitution through its decisions. And more than 11,000 amendments have been introduced in Congress, but only 33 have gone to the states to be ratified, and then only 27 have received the necessary approval from the states to actually become amendments to the Constitution. By contrast, we can consider constitutions in other countries with written constitutions. So for example, India's current constitution was ratified in 1950, and it has been amended 106 times. Canada gained the ability to amend its own constitution in 1982 and has amended its constitution 13 times. In France, this current constitution was adopted in 1958 and has been amended 25 times. So compared to these other countries, the US has relatively few constitutional amendments for such an old document that continues to govern our form of government today. And so some of the interesting things that some countries have done recently as far as amending their constitutions has been introducing provisions such as clean environment provisions in their constitutions. And so those are things that countries that have constitutions that are easier to amend can achieve when they amend their constitutions. So then we'll take a look at state constitutions. 49 state constitutions expressly recognize popular sovereignty and commonly state that all political power is inherent in the people. Every state constitution also confers the right to vote, and a majority require that elections be free and equal, or free and open. And in nearly half of the states, though not unfortunately here in Wisconsin, there are direct democracy provisions that allow the people themselves to enact or reject statutes, amend their constitutions, and recall officers, which is a power that we have here in Wisconsin. Under the state constitutions, voters frequently elect more than just the chief executive. So if you think about who we elect at the federal level, we elect our Congress people, and then we also elect the president. But under state constitutions, voters frequently elect other members of the executive, such as the attorney general, and also elect judges. And then state constitutions can provide more robust protections for rights in the US Constitution, which frequently serves as a floor rather than a ceiling on the rights that we have here in this country. So in part, we can owe some of these expanded rights to amendments. So there are a number of states that have introduced what is commonly called green amendments to their constitutions, which enshrines a right to a clean and healthful environment in their state constitution. Several states also expanded suffrage to women before the passage of the 19th Amendment through amendments to their own state constitutions. And so these are different ways that states have the ability to give their citizens more rights under their state constitutions than we might see under the US Constitution. But we can also attribute some of these expanded rights to the ability of states to adopt new constitutions as needed. And many states, when they think about calling constitutional conventions, think about it as providing their citizenry with a constitution that meets the needs of a changing state or their current population. And so Wisconsin is actually relatively unusual amongst the states for still being on its first constitution. There are only 12 other states that have not adopted another constitution since the constitution that they adopted for entry into the Union, and this includes significantly younger states such as Alaska and Hawaii. So I'm just going to show a few maps that are going to show the different provisions that state constitutions have. So this is a map showing constitutions that have a general equality provision. So this generally prohibits things like private, special, or local laws, and then provides equal protection guarantees. And so an interesting fact about the equal protection clause in the Wisconsin Constitution is that in 1982, there was an amendment to the Wisconsin equality provision, which made the equality provision gender neutral. And so it previously said all men, and then it said, after this amendment, all people. And so it's actually not uncommon amongst state constitutions to amend their constitutions to make them gender neutral, or in other cases to explicitly bar discrimination on the basis of sex. So this is another map showing open government clauses in state constitutions. So these are the sorts of clauses that might require public access to most government proceedings or give public access to government documents subject to certain exceptions. And so those clauses might also be known as right-to-know clauses. And so this allows a citizenry to be informed about what is happening in their government and to really be engaged in an informed way in how their government is being run. And then the states highlighted here in orange are those states who have with constitutions that include a public purpose clause. And this just explicitly limits government spending only for public purposes. And so now we're going to focus in on Wisconsin constitutional amendments from when Wisconsin ratified its first constitution to the present. And so just by way of background, to amend the Constitution, the legislature has to pass, by a majority in both houses, a proposed constitutional amendment in 2 successive legislative sessions. And then once this amendment is passed by 2 successive legislatures, then it goes to the voters to be ratified. Voters also have the opportunity to reject the proposed amendment, as voters did this past year with the August amendments. And so the interesting thing about amendments to the Constitution is that the governor does not have the opportunity to veto proposed constitutional amendments, which can make amendments a useful tool if the legislature is controlled by a party different from the party that controls the governor's office. And so you can see here that the Wisconsin Amendment has been amended 151 times since the Constitution was ratified in 1848. And this has resulted in over 200 textual modifications to the Constitution, since sometimes amendments affect more than one provision in a Constitution. And you'll notice that there is a period of high activity in the 1960s, 70s, and 80s. And so when you take a historical view of constitutional amendments for the Wisconsin Constitution, we can see that although it seems like there's been an uptick recently, that there have been times in the state's history where there have been significantly more amendments that were being proposed and passed. So by contrast, since 2010, only 11 constitutional amendments have made it onto the ballot, and only 8 have passed. So then I'll briefly discuss the recent amendments that have been on the ballot. I'm sure that folks in this room and online are aware that we voted on 5 amendments this year and passed 3 of them. And so first there were the election administration amendments. The first one would have limited the local government and election offices' abilities to use outside equipment or outside funds. And then the second was to only allow election officials to administer elections. And so as you can see from these 2 maps, the top map with more states colored in is the number of states that have adopted bans on election officials being able to use outside funds. And then the bottom map is the number of states that have limited election administration to only election officials. And so you can see that Wisconsin is not necessarily an outlier when it comes to adopting these 2 amendments, especially with the first amendment. Wisconsin was actually adopted the amendment relatively later, and this is because of the 2 successive legislatures rule, whereas some other states were able to adopt these immediately after the 2020 election. And then this is a map of states that have either states where there is local non-citizen voting or states where there have been bans on non-citizen voting. So all of the blue states are states where there's an explicit prohibition against non-citizens voting, and then the orange states are those states where there are some localities within those states that allow non-citizens to vote in local elections. So historically, a number of states actually employed a declarant model for voting for non-citizens, and so this is also true of Wisconsin. And so essentially, the Constitution would say something like, a non-citizen may vote if they declare their intent to become a citizen. And so that was the case in Wisconsin until 1912, when an amendment to the Wisconsin Constitution eliminated this option for non-citizens to vote. And so that took away an explicit right for non-citizens to vote in Wisconsin elections. But it didn't actually explicitly prohibit them, and that's what this most recent constitutional amendment did. And so even though you can see there are a lot of states that have banned non-citizen voting, it is actually relatively rare. So only 17 out of the over 35,000 towns and cities in this country allow non-citizens to vote in elections, and 11 of those cities and towns are in Maryland. And so now I'm going to give a little bit more of the national context of state constitutional amendments. And so in 2024, voters across all 50 states voted on 97 constitutional amendments and approved 62 amendments. 3 of those were here in Wisconsin. Some states voted on more constitutional amendments than we did. So Arizona voted on 8 constitutional amendments during 2024, and then some states passed more. So for example, Colorado and Louisiana passed 5 constitutional amendments this past year. And to just provide an even further back look at the number of constitutional amendments, you can see that in general, on even election years, there are generally a relatively significant number of constitutional amendments being proposed and passed across the country. And you'll note in 2022, Alabama adopted a new constitution. And so generally that was to reorganize their constitution. But one of the notable things that they were trying to do when adopting this new constitution in 2022 was to delete racist language from their constitution, which is something that was a holdover from the previous constitution that they felt was important to get rid of when they were adopting a new constitution. So the process of amending state constitutions differs from state to state. For legislatively referred constitutions, constitutional amendments, which is what we have here in Wisconsin, it must pass the legislature, sometimes more than once, as here in Wisconsin. Sometimes it must be passed by greater than a simple majority, and then it must be approved by voters. And so the percentage of voters that need to approve a legislatively referred amendment also differs from state to state. So here in Wisconsin, it's a simple majority, but in other states, depending on what the part of the Constitution is being amended, sometimes it takes more than a simple majority. And then 18 states allow citizens to initiate constitutional amendments. And generally, this is achieved by setting a signature requirement. And once they collect the requisite number of signatures from the various counties, they are able to put this constitutional amendment on the ballot. And even though you make it onto the ballot, that doesn't mean that it'll still be approved, and so it still requires ratification by the rest of the voters. And so an interesting thing that happened is that on Monday, Governor Evers announced that he was going to include in his budget proposal a proposal that would require the state legislature to create a pathway for people in Wisconsin to place binding referenda and constitutional amendments on the ballot. And so this is something that would be a really interesting thing to introduce into the Wisconsin political landscape, especially since citizen-initiated referenda and amendments could allow the people of Wisconsin to enact popular policies that wouldn't otherwise pass the legislature. And then finally, there's the convention method. And so there are 12 states that actually, on a recurring basis, ask their citizenry if they would like to hold a constitutional convention. And so that's usually every 10 years, there's a question on the ballot that asks, should we call a constitutional convention? And so some legislatures may propose calling a constitutional election, and then there's a few states where the legislature can unilaterally call the constitutional convention without taking this to the voters. And then there are 8 states that have no kind of process for doing this, though theoretically there would be some way of calling a constitutional convention in those states. And so constitutional conventions can do things like propose amendments, but they could also propose revisions, which are larger scale amendments to the Constitution, or suggest adopting a new constitution altogether. And so there have been states that have called constitutional conventions, had the Constitutional Convention create a new constitution, and then had that constitution rejected by the voters. But then there are also examples of the opposite being true. And so this is just a handy little table that shows the different ballot content requirements. And so this is the type of information that is provided to voters when they're voting on a constitutional amendment. And this varies greatly from state to state. So there are some states that will provide significantly more information, such as statements from supporters and statements from opponents to a constitutional amendment, and will provide every voter in the state with a full copy of the text of the amendment and provide additional background information to make it easier to understand what it is that someone is voting on, which is different from what we have here in Wisconsin. And so now we'll turn to amending the US Constitution. So there are two methods of amending the US Constitution. The first is an analog to the legislatively proposed amendment. So it would be proposed by 2/3 majority in both the House and the Senate. And then it wouldn't require a presidential signature. It would go directly to the states to be ratified. And then amendments would have to be ratified by 3/4 of the states. And depending on what is stated in the joint resolution, it either goes to the state legislature or to a state ratifying convention. Or something that has been percolating in the popular consciousness is the convention method of amending the Constitution or adopting a new Constitution. So it's called by Congress on application of 2/3 of state legislatures. And aside from the original Constitutional Convention that resulted in the Constitution that we have today, there's never been a federal Constitutional Convention. So it would be exceedingly, this is something that would be just quite unusual for our country if we were to call a constitutional convention. But there are a number of current efforts to call constitutional conventions. Notably, a group that is trying to pass a balanced budget amendment has seen 28 states adopt a petition to call a constitutional convention to call this amendment. There's also the Convention of States Project, which has been supported by 19 states, and then the term limits campaign has also been adopted by 19 states, and then the one with the fewest support, which is the Wolfpack campaign, has been adopted by 4 states, which would seek a federal free and fair election clause. And so all of these efforts to seek a constitutional convention are being called with a limited purpose, though some of these campaigns are broader than others. So hopefully through the previous part of this presentation, you would have seen that amending constitutions and adopting new constitutions is not inherently something to be feared or opposed, and that there are a lot of opportunities that might be presented by amendments and engaging with the democratic process in this way. And so I'm just going to briefly go over some of the opportunities and challenges with amending constitutions or adopting new ones. So with state constitutions, there are some primary challenges to how we amend our state constitutions. And so a big one is the manipulation of election timing. And so it can be the case that when amendments are being proposed, that they be set for elections that see historically low turnout, such as special elections or off-year elections. And so when there's low turnout, this historically excludes historically marginalized communities and can result in a smaller number of voters having an outsized impact on our Constitution. And then there's the other way that one might try to manipulate election timings to place an amendment on the ballot when you want to boost voter turnout in certain groups by placing some sort of amendment on the Constitution that would be of interest to particular voters who might be in support of particular candidates or particular other races. Another issue is that ballot language is often very confusing. People may not know that they're going to be voting on a constitutional amendment when they show up to their polling place. And then when they get there, they're confronted with this question that is worded in such a way that doesn't make clear exactly what is going to be achieved by the constitutional amendment, or might be deliberately worded in a way to be confusing to voters. And so this may lead voters to abstain from voting, or they might vote contrary to how they would vote if they were given the complete set of information they need to understand what would be achieved by this constitutional amendment. And then there are also ongoing efforts to limit direct democracy. So this is not an issue that we're seeing here in Wisconsin, since there are very limited ways in which voters are engaging directly with the democratic process aside from voting for their representatives and voting on constitutional amendments. But there are other states where they are attempting to raise a threshold for passing an amendment, or raise a threshold for getting an amendment onto the ballot. So this would be citizen-initiated amendments, and this might be in response to times when the legislature is opposed to a particular policy, but this policy is relatively popular with voters, and so a way of preventing that from being passed without the legislature's ability to control the outcome of this vote would just be to change the amendment process in order to make it more difficult for voters to place an amendment on the ballot or to pass that amendment. There are also efforts by parts of the government to prevent ballot measures from getting onto the ballot in other ways, such as challenging them in court or denying citizen-initiated ballot measures from getting on based on the title or the description, and trying to manipulate or affect the outcome of the elections in this way. There are also legislatures that are actively looking at constitutional amendments or other pieces of citizen-initiated statute and immediately amending that afterwards, or proposing amendments to things that have already passed by the voters, and trying to get involved in that process in that way to limit the effects of these citizen-initiated statutes or constitutional amendments. And so there are states that, and so I think that I think that despite all of these challenges, there are also a lot of opportunities with state constitutional amendments. And so you can look at enshrining the opportunity to enshrine additional rights in the Constitution. And so, for example, there are a number of states that enshrined abortion rights after the Dobbs decision. And so that was achieved through the constitutional amendment process. And I think that we can also think about a living constitution as a way of making sure that the Constitution continues to work for the people in the current moment. And it's important because if we think about the different ways that we interpret the Constitution, every single time the Constitution is amended, the people create a new original moment in which we look to think about what values should inform the ways that we see the Constitution and what sorts of rights it should provide to people. And then, as I have already discussed, that there can be responses to changes in the federal legal environment that might not otherwise be possible at the federal level. And so then we can look at the US Constitution. And so one of the big challenges with amending the US Constitution or adopting a new US Constitution is that Article 5, which governs the amendment and the amendment and convention process, isn't actually that specific. So when you look at just the text, there are a lot of different ways in which you could see a convention being run, and that leads to some challenges and opportunities. And so one of the big fears of people who are opposed to a constitutional convention at the federal level is that there is fear of a runaway convention. And so this is the case where if you call a constitutional convention for a limited purpose, it may be the case that delegates could then take that opportunity and this power to go do a bunch of other things that were not part of the petition. And so that's what is usually called a runaway convention. And so some of the ways that states have been trying to address this is by creating limited petitions for constitutional conventions and including the right to recall delegates if they don't follow the limited petition. There's also a number of states that have passed faithless delegate laws, and so this would essentially penalize any delegates who choose to act contrary to the petition that was submitted to Congress to call the Constitutional Convention. Another challenge is that it's not entirely clear how delegates would be selected. Would it be the state legislature or would it be the people? And it's just not clear from the text of the Constitution what that answer is. And so there is one faction of people who are interested in constitutional conventions that would state that we look to how it was done back when we ratified Article 5, and in that case, then that would be the state legislature. And there's also issues related to how much representation would states get. Would it be 1 vote per state, or would it be proportional? If we look back to how it was done in the past, it would be 1 vote for a state, but there's nothing in the Constitution that says that this must be the case. And then also the passage requirements. So we already know that the application by the states needs to happen by a certain number, but Article 5 doesn't say how many votes we need in Congress to actually call the convention. So there's a question of whether or not it would be decided by a plurality across both houses of Congress, or whether or not there's only a need for a simple majority, or if in fact there needs to be a supermajority in Congress in order to call a constitutional convention, even if the requisite number of states have filed an application. And so despite all of these challenges, there are also opportunities. And so in the past, when there's been calls for constitutional conventions, this has motivated Congress to act in ways that they might not have had the political will to act before the threat of a constitutional convention. And so in this political climate where we have a lot of congressional inaction, and it might be the case that having the threat of a constitutional convention can encourage Congress to work together to pass laws that might be popular amongst the people. It's also the case that Congress could enact rules to govern the convention process, and so it's not clear that these rules, if passed by Congress, would be binding, but it's a way for Congress to preemptively be engaged in the process and really think about how we should be structuring a constitutional convention instead of just pretending that it's never going to happen. And another opportunity is we could update the Constitution or adopt a new one. And when you think about that in the context of the legal theory of originalism, this could be a really powerful tool to change the framework with which we view constitutional provisions, even if we don't end up actually adopting significantly different ones, because the social environment and how we understand these provisions might be different from how they were understood when they were first adopted. And so I think that I think the big takeaway from this presentation that I hope that everyone will get is that it is important to confront the possibility head on that there could be a constitutional convention, and that constitutional amendments are part of how we update constitutions and allow and part of confronting this possibility or opportunity head on is to really think about how we would want a constitutional convention to be run. And so right now, this conversation is being dominated by groups that are interested in calling a constitutional convention, and by allowing them to frame the conversation, their position becomes the default. And by having other groups with different positions on constitutional conventions engage with this idea actively allows for an alternative to be presented and might lead to a better outcome when it comes to constitutional conventions and what it would look like if it were to happen. So just quickly before I turn it over to questions, I wanted to highlight a resource that the State Democracy Research Initiative has been putting together. And so this is 50 Constitutions, which is, you can reach online at 50constitutions.org. And it basically allows individuals in states to search across state constitutions and within their state constitutions, and has the current text of every constitution available right now. But in addition to that, for the shaded states, we have the full amendment history for those constitutions. So you can look at the Constitution as it stood at any point in time, and also use track changes to see how provisions have changed with amendments. And so actually this one. So this is the track changes feature, and we had discussed the equal protection clause in the Wisconsin Constitution and how it became gender neutral. And you can see that this was how the change was made in 1982. And then another feature of the website is there's an annotated timeline that highlights important constitutional moments of history for the states that have been shaded, and gives kind of more information, background, and a discussion of the various effects of these constitutional amendments that have been made in those states. So thank you. And so you can see that's the URL for that resource. And we also host a bunch of events and post a lot of research on different issues. And so if you're interested in learning more, that's our website.
Thank you, Emily.
Yes, thank you very much. My question has to do with the calling of a convention, and the particular one that came up on your slide was the one that I think our legislature did during the Walker administration, which was to the funding one, and there are 28 of so many states. 28 is getting pretty close. So my question is that ever time limited? In other words, if Wisconsin would decide we don't want to do this, do they have to revoke that calling for a convention on that basis? Is that the process, or is it just out there forever until enough states sign on? Do you understand what I'm asking?
Yes, yes. So I do believe states can revoke their petitions. It's also the case that there's some disagreement about how identical petitions need to be in order to be grouped together as part of the same call for a convention. And so there are some scholars who believe that substantive similarity is sufficient to group these together. And then there are other scholars that believe that petitions need to be identical in order to be considered part of the same petition. So the count may be different depending on who you ask. So it's an area of the law that is underdeveloped in part, or especially because we've never called a constitutional convention since the original one.
You really did a very good job of summarizing. Many of you know that the League has a book club, and our League read Russ Feingold's book on this. It's like the constitutional amendment or amending the Constitution. And a bit of it is a sleeper, a bit of it is really good, but he brings up all these questions, but what he says is we don't really know. But it is a very good book if you want to go into more depth.
Given all the ambiguities that you presented here, suppose an entity goes down a direction and seizes on, for example, representation in a way that doesn't seem fair. Are there legal tools to slow that, to halt that, or to keep it into question, or litigation possibilities as things begin to develop in a light that doesn't seem fair? Are there tools? I guess that's the question.
Yeah, so certainly there would be opportunities to litigate or to otherwise legally challenge the process of forming the convention, of how the convention is being run. I think that the difficulties with these challenges is, again, this ambiguity in the text. We only have Article 5 to look to, and unfortunately, it doesn't provide a lot of guidance as to what is the correct way or the wrong way to run a convention. So it might be the case that even though there could be a challenge, that it could be said that all of these ways that we could run a convention are legitimate, and it just happens to be that whichever group got in first chose this method. But it could also be the case that there are other provisions in the Constitution that, such as the Equal Protection Clause, that might weigh in favor of other forms of representation that are more proportional or more representative of the people.
So I take it from everything that you've presented here today, a president of the United States cannot just suspend the Constitution. Correct.
That's correct.
You referenced that sometimes the constitutional amendments are written and difficult for people to understand whether that's intentional or not is unclear. But are there some states that say that you have to write constitutional amendments in a language that the people can understand?
So I think that in general, states do not have limits on the language of the amendment itself, but there are states that have rules about explanations for what the amendment would do. And so there are states that have requirements that they not bias voters in favor of one outcome or the other, or require that they not be confusing. And so it depends from state to state, but there are some states that have requirements about how we describe these amendments, even if there are no specific restrictions about the constitutional amendment text itself.
Thank you so much for your presentation. You mentioned that in the conversation that's now underway about how to organize a national convention, that it's being dominated by the forces that want to have a convention, and that others need to get involved. That's very helpful, but can you name some possible organizations that you think ought to be a part of this conversation?
Well, I think that the League is involved in this conversation, and I think that it's really important that organizations like the League continue to be involved in this conversation, to think about what a constitutional convention could look like, even if it's not necessarily something that the organization might want to be in favor of kind of fully committing to. And just having these different voices can be really important, just to ensure that we are seeing that there are different possibilities or outcomes with constitutional conventions than just the ones that are being proposed by these organizations that are really, really interested in changing the Constitution in a way that, that they believe is in line with their ideology.
I don't have a mic, but some of the older members may recall that we did a study on this issue. I'll get mic and yeah, some of the longer-term members here may recall that we studied this issue for a national position on, and the same issues came up. What's fair representation? How do you elect delegates? All those kinds of things. So that is out there if you can access it. I don't remember exactly when, 10 years ago, longer? Yeah, I think it came up during the walk, when these people were suggesting we have a constitutional convention on that funding issue, the one where there are 28 of, was it 33? Yeah, balanced budget. So that information is there, and our position was that we opposed a constitutional convention, but you can, if you read that, you will get some more information about the issues that come up in considering a convention.
Jane thinks it was 1979.
Thank you for your presentation. It's great. You talked about one of the downsides of amendments on the ballot in Wisconsin could be inconsistent information. And related to that, is there a requirement for how well the publicity gets out or when it gets out? Because it seems that no one knows anything about these amendments except by word of mouth or some League member happening to write a letter to the editor at the last minute. I ran a canvassing station for my community this fall, and the canvassers are well-educated, informed people, and no one knew about the amendments. So what is required in Wisconsin regarding that?
So I actually can't recall right now the exact requirements in Wisconsin. The publicity requirements in general across the nation are relatively low. And so a number of states say that you have to publish the text in a certain number of local newspapers for a certain number of weeks before the election. And it's quite limited. If you're not if you're not subscribed to a newspaper, if you don't flip through every page of the newspaper, you're not going to see that information, even though that is kind of how states generally publicize amendments to voters. There are some states that have requirements of including these in voter information pamphlets that are mailed out to all voters, but that's not the case here in Wisconsin.
So thank you. I wanted to just comment on where can we get information, and Maureen mentioned Russ Feingold's book. And I think if you just Google Russ Feingold and Article 5 Constitutional Convention, and if my memory is correct, it's like the American Constitutional Society, I think you will get into information about pros and cons of a constitutional convention. And I do remember, I think it's been in the last 10 years, Ellen, that we did that. I don't know if we can find that. There was a lot of documentation with that study that we were asked to look at. We can see if we can find it and let people know about it.
I'll piggyback off what Deb just said. The group that put this program together had a number of good resources, and they are on the event page on our website right now, but they will be moved over to the recording. So as soon as the recording goes up, which will be within a couple of days, there'll be a list of a number of resources, and Feingold's book isn't there, but some of that same kind of information is there. And then could I ask a question too? Could you tell us a little more about Governor Evers' request for citizen initiatives and the budget request? Do you have any idea how that will work and the likelihood that it'll survive? Because we are one of the states that does not have any revenue or any avenue for that to occur. So I'm interested in seeing if that'll make it.
Yeah, so I don't have a lot of details right now. All I've seen was Governor Evers' press release on Monday announcing that this would be something that's included in the budget. There is the opportunity that it wouldn't survive the whole budget process, but it is an important conversation to be having as far as whether or not this is something that we should have in Wisconsin. I think that there are experiences in other states that might mitigate in opposition to adopting this. For example, in California, they have a lot of propositions that show up on their ballots, and so then now voters are not just required to think about the 1 or 2 constitutional amendments being proposed by the legislature, but the 5 or 10 statutes being proposed by the citizens, and then other constitutional amendments that are citizen initiated, and that can greatly increase the burden on voters when they go to the ballot box, to their polling place, to think about their positions on every single one of these amendments or statutes. And so there are some downsides to adopting such a process, though I think in general, anything that increases our ability to participate in the government is in general a good thing in order to have the views of the people represented fairly in their government.
Thank you, Emily, for coming today. Hey, I have a quick question for you. If Donald Trump wants to stay in power forever, is that possible?
As a disclaimer, this is not my area of expertise. I study state constitutions. I would say that it would not be something that is constitutional, but I will just trail off.
In response to the Evers' introduction into the budget and reaction, I mean, already the reaction from the majority legislative leaders is that that's as dead as, I forgot what as dead as a nail or whatever can be. But it seems like of the 5 amendments that were introduced during this last year and voted on, the one that was defeated was one that a lot of democracy groups all really pushed. And there were signs out, and there was information, and it was like a united effort against that amendment, and that one is one that did fail. So it seems like when everyone comes together across the state, all of the groups together, that they do get the information out. But that was the only one that I think was a united opposition to, and the others, passed. So.
Okay, one more question.
Thank you. When you mentioned that the text of the amendments had to be nearly the same or the same, is this the role that ALEC has played across our nation?
So,
The American Legislative Exchange Committee?
So there are several organizations across the country that propose model language for constitutional amendments in the states. And so here in Wisconsin, because amendments have to pass in 2 successive legislatures, the language has to be identical each time when they pass it. If not, that restarts that process. But states are able to modify that language if they want to. And so there are organizations that are engaged in the state constitutional amendment process across the nation to promote various amendments to state constitutions. So I would say it's not just ALEC, but there are a lot of other organizations that are engaged in similar projects for other issues. So for example, the Green Amendment folks there is an organization that specifically works with states to introduce amendments to protect the environment in state constitutions.
All right, thank you. Nicely done. Well, we really appreciate Emily's insight and explanation of so many details involved in all of this, and it does sound a little like a call to action for us to pay attention as we're going forward. So thank you all for coming. I'll give a couple announcements as usual. Our book club is going to meet the last Monday of the month, and yes, Maureen Kinney is our book club person. Here we go.
The book club for January has gotten mixed up. Nobody's fault. I ordered it through interlibrary loan, and we were going to get like 8 of them. And I found out yesterday that my person at the library, it wasn't her, somebody in the system hasn't put the books in, and there aren't that many of them, and they might be coming. Is that very helpful to you? But Hoopla is the library app that you can get books on. I am mixed up on how to get mine, so I'm going to go in and ask for some help today, but I know that you can get it through Hoopla, but I don't know if there's a limit on how many the library can put out on Hoopla to people at any one time. So anyway, that's the name of the book. It's A Boys and Men. It's in the newsletter. Okay, yeah. So, I mean, you can buy it from other places too, Kindle or wherever, but the Hoopla through our library is free if you want to look at it.
Thank you, Maureen. There is an area on our website you can sign up for the book club. You don't have to, but more information is on the book club for the time and place. The next meeting that we're going to be having in February for our educational program is an evening webinar. That'll be February 12th, and the title is Improving Civic Health and Why It Matters. So civic health is what keeps communities working together to solve difficult problems. And so we're going to have a speaker, another UWL educator that has been part of a group that published a Civic Health of Wisconsin report in 2000, and there's another report coming out in 25. And so she is going to be our speaker to explain more about civic engagement and civic health as we solve important problems. Registration and more information and resources is also on our website for this program. And then finally, in February, we're going to be launching a new league membership system. So I'm just going to say a few words about that. You may have heard rumors. This is going to be a system managed by the League of Women Voters of the United States. You'll still be joining our local league and renewing your membership with the local league and part of the state and national league as well. You'll be members at all 3 levels, but the process will just be a little bit different. There was a brief message in the news update that came out yesterday, and we will continue to have updates in our news letter twice a month. And also, we will be sending out a letter later in January. We do have a core team of local members working with the national staff to make the changes as seamless as possible. And it's just one of those new things. The goal is to increase membership across the country by making a range of dues limited, or a range of dues membership amounts to increase membership throughout the country, and also to try to relieve some administrative burden from local leagues. We are a pretty sophisticated league with a strong communication team and website, but not every league in the country has the wonderful resources and skills that we have. So it's to help the league in general throughout the country. That's all I have today. Oh, one more thing. Our Voter Services Chair, Chris, wants you to know we do have posters or yard signs up for the February 18th primary, which will be happening. Feel free to go over and get a stand and a yard sign if you don't have one. Those of you that do this regularly, you may have your stock somewhere in your basement ready to go, but oh, and there dates too. So if you do have them and you want to get some of the laminated dates to tape onto your signs, the resources are all over on the table. So great to see you all. Thanks for coming, and we'll hope to see lots of you next time on Zoom.